get through this PowerPoint really fast. All right, our next speaker of the day is Ms. Mary Burdette. Ms. Burdette has been a partner at Calloway, Norris, Burdette, and Weber since 1994. She practices probate, trust, and fiduciary litigation, estate administration, guardianships, and wills and trusts. She received her law degree from SMU in Dallas, Texas. Not only is Ms. Burdette board certified in estate planning and probate law, as well as tax law, but she is also a certified public accountant. Since early 2000, she has consistently been named a Texas super lawyer in the area of trust and estate litigation, and she has been listed in the best lawyers in America for litigation for trusts and estates. Today, Ms. Burdette will be speaking about remedies for breach of fiduciary duty. Please welcome Ms. Mary Burdette.
Good afternoon. You're almost through. I'm going to have to set a timer for myself because I have a plane to catch and I have to leave right at 3:15. So it was the last flight, the last nonstop flight, and I sure didn't want to spend Friday evening catching several flights back to Dallas. But I certainly appreciate being here today. My topic is on remedies for breach of fiduciary duty. I am going to first sort of go over some of the rules that apply to remedies for breach of fiduciary duties, and then at the end I've got a couple of case studies that I think will be helpful in illustrating these concepts. I'm not going to be talking about specific fiduciary duties. The paper covers those duties, and so you can read the paper about that. But generally, fiduciary duties fall into about four general categories, which are the duty of loyalty, the duty of competence, the duty of full disclosure, and the duty to reasonably exercise discretion. The type of breach that you're looking at or that you're dealing with is going to have some effect on the remedy that you're seeking, whether you're going to be seeking damages or removal or compel the trustee to provide information or distribution. So the type of duty certainly has an impact in the remedies discussion. Remedies for breach of fiduciary duty reflect the extremely high duties that are owed by fiduciaries. These remedies are broad, they're flexible, they're equitable, they're skewed to the beneficiaries, and they're designed to let the courts design a plan and a remedy that will protect the trust, will protect the beneficiaries, and basically try to put the beneficiaries back in the position that they would have been if there had never been a breach. Although trust remedies or breach of fiduciary duty remedies are equitable in nature, the Trust Code has codified most of them in Section 114.008. This section has a long list of remedies for the breach of a duty by a trustee. And I think this starts on like page 9 of the outline, or 9 or 10 maybe at the outline. You'll see this list, and I'm going to be following the outline fairly closely, but just not word for word. So some of these remedies include compelling a trustee to perform their duties, enjoining a trustee from committing a breach, compelling a trustee to redress a breach, to put back property or to pay damages, ordering a trustee to account, ordering a receiver to take possession of trust property, suspending a trustee, removing the trustee, reducing or denying compensation of a trustee, voiding the act of a trustee, imposing a lien or a constructive trust over trust property, or tracing trust property of which the trustee has wrongfully disposed, and then the catch-all of any other appropriate relief. The probate code doesn't contain a similar litany of remedies, but the law is clear that executors and personal representatives hold estate property in trust, and they owe the same fiduciary duties as trustees. So basically the same remedies are going to be available for breaches of duties by personal representatives, also guardians and agents under powers of attorney. But the probate code, I'm never going to get used to saying the estates code. The estates code does provide some specific provisions for breaches by the independent executor. And these include seeking a bond for an independent executor who's mismanaged property or betrayed his trust, or demanding and compelling an accounting from an independent executor, although you can't do this until at least 15 months from the admission of the will has passed. Also, beneficiaries can compel distribution of the estate after 2 years. An independent executor can be removed under the specific situations prescribed by the code. And an independent executor is prohibited by statute from purchasing estate property without a court order. It's one of the few things that an independent executor can't do without a court order. And there's a provision that permits a beneficiary to seek to void any purchase in violation of that provision. Now, there may be some limitations on remedies available to deal with executors or independent executors that don't exist for trustees because of what I will always think of as Section 145. Is now Estate Code 402.001, but that's the provision that creates an independent administration or executor and provides that the courts do not have continuing jurisdiction or supervisory authority over independent executors. So you may not be able to go in and compel an independent executor from taking actions in administering the property or not taking actions because that would probably be an impermissible interference by the court. But certainly beneficiaries can sue an independent executor and in connection with that suit seek to have them restrained or enjoined or even a receiver appointed if necessary to protect the estate. The particular remedies that you're seeking are affected by who the parties are. The beneficiary, who's typically the plaintiff, sometimes the successor trustee, but if the beneficiary is suing, they're either going to be suing to recover money individually. Usually that's a good example of that is where the beneficiary is complaining about not receiving sufficient distributions. So well, actually, that's the opposite. The beneficiary seeking, complaining about not receiving sufficient distributions is actually looking for money to come out to him personally, where, on the other hand, a beneficiary may be seeking to recover remedies or damages for the trust. So he's suing in sort of a derivative position on behalf of the trust and not seeking to recover personally. On the defendant side, the trustee will either be named individually or in his fiduciary or representative capacity, depending on whether the plaintiff is seeking damages from the trustee personally or damage from the trust itself. So if you're seeking damages from the trustee personally out of his personal assets, you're going to be suing him in his individual capacity. But if you're seeking damages from the trust, then you would be suing him in his representative capacity, and oftentimes it's in both capacities. The most common remedy, of course, that we see is the remedy of damages, and the trust code prescribes 3 rules relating to a trustee's liability for damages. First, a trustee is personally liable for damages resulting from a breach of fiduciary duty. Conversely, a trustee is not liable for a loss in the value of trust property or for failure to make a profit if that is not a result of a breach of fiduciary duty. And it's This is a kind of a common mistake I see, because some plaintiffs, or contrary to what some plaintiffs' lawyers think, a trustee is not liable just because there's a loss in the trust. A loss in the value of the trust may occur, but unless that is connected to a breach of fiduciary duty by the trustee may not be liable for that loss. And number three, even when there is no breach, the trustee is going to be accountable for all the trust property and for any profit that the trustee makes in his position as a trustee. The elements of a claim for damages for breach of fiduciary duty are a fiduciary relationship, a breach of fiduciary duty, and an injury to the plaintiff or a benefit to the defendant that results from a breach of fiduciary duty. And this third element is the causation element. And so it's not enough to prove that interesting. Okay. It's not enough to prove that the trust actually suffered, that there's a trust, so there's a fiduciary relationship and the trust suffered loss. You also must prove that there was a specific breach of trust and that this specific breach of trust caused the damages that you're seeking. Phone went off. I have to watch my time. Okay. The causation standard for damages against a trustee is prescribed by statute, and it is damages, quote, resulting from. That's the key phrase. The damages that are resulting from the breach of the fiduciary duty. This is in Trust Code 114.001. In non-trust breach of fiduciary duty cases, the causation standard is the proximate cause standard. What damage that were proximately caused by the breach. So you have to be careful that you're using the correct standard. What's the difference? Not entirely clear, but proximate cause does contain a foreseeability element, that the damages must be foreseeable, and that element may not be included in the resulting from standard in the trust code. The case law will ultimately develop those rules. So the standard for an executor is probably proximate cause because there is no similar statute in the estates code that changes that standard or prescribes a specific standard. Proving causation requires evidence, a probative force. You can't just, it's not just speculation, it's not guess. You've got to directly connect the breach with the injury. I'm not going to have time, but I'll just reference you to the Baker-Botts versus Calloway case, which is an interesting case for a lot of reasons, but it actually, in that case, the court found there wasn't sufficient causation because the evidence was too speculative. What is the measure of damages? Well, the trust code prescribes 3 specific measures of damages. First is any loss or depreciation of the value of the trust estate as a result of the breach of trust. This is sort of the compensatory damages component, like we see in contract law. Second is any profit made by a trustee through a breach of trust. And third is any profit that would have accrued to the trust if there had been no breach of trust. And this is sort of the lost profits element. The new probate and trust pattern jury charge provides what sum of money would fairly and reasonably compensate the trust estate for the damages resulting from the breach. Okay. Of course, a judgment for damages is only as good as it is collectible. Typically trustees and independent executors are not required to bond. There's no net worth requirement, so sometimes it may be difficult to collect a judgment for breach of fiduciary duty against a trustee, particularly an individual trustee. However, if a trustee is a beneficiary, you may be able to satisfy a judgment against that trustee out of his share of the trust, even though it's a spendthrift trust. Trust Code Section 114.031 provides that if a beneficiary owes the trust money, that debt may be offset against distributions to that beneficiary. So that's something to keep in mind in collections, and also it may give you a little leverage in a breach of fiduciary duty suit. The next remedy I want to talk about is the remedy of constructive trust. This is an equitable remedy to prevent unjust enrichment of the wrongdoer. It is a remedy. It's not a cause of action. It's available for breach of fiduciary duty, and it's not a trust. It allows a plaintiff to recover specific property from the trustee or the executor or an assigns instead of getting money damages. This remedy imposes, the way it works is it imposes an equitable duty on the person holding the property to convey it to the trust or to the estate. Now, why would you want a constructive trust as opposed to a money damage judgment? Well, there are several reasons. One is where the trustee is judgment proof. You may be able to obtain a constructive trust over property that would be exempt from satisfying a money judgment. Another reason is if the trustee has multiple creditors and there's a limited number of assets, then all the creditors are going to be chasing after the same property and will probably end up having to share it. But if a plaintiff obtains a constructive trust over a particular asset, then that plaintiff gets that property exclusively and to the exclusion of the other creditors. And then another situation is where the property you're seeking a constructive trust over has appreciated. So you not only get the property, you get the appreciation in the property. The elements of a constructive trust, there has to be a breach of a fiduciary relationship. There must be unjust enrichment, which basically means that there is some person, usually the trustee or someone they've transferred property to, who obtained a benefit through a breach that would be unjust for them to retain. And you must be able to trace the trust property or the estate property into identifiable property or fund. Now, this tracing rule is probably the hardest part about a constructive trust remedy, but there are some tracing rules that tend to assist the beneficiaries in their tracing. For instance, if the trustee commingles trust money with his own personal money, the tracing rules provide that the entire fund will be treated as subject to the constructive trust. If any funds are expended out of that commingled funds, those are assumed to have been expended, the trustee's funds have been expended and dissipated, and what's left belongs to the trust. And then if the trustee has expended funds to purchase property, then that entire amount that was used to purchase the property is presumed to be trust funds unless the trustee can prove specifically what assets and what funds are his. Okay, let's talk about some other remedies that are sometimes referred to as special fiduciary remedies. And these remedies do not require that the breach result in a loss. They may result in a loss, but they don't have to result in a loss to the trust. The first is fee forfeiture. Even though the code may provide for a trustee to be compensated or an executor, or the instrument provides, a fiduciary is only entitled to compensation if he properly performs his duties. Under the trust code, the court may deny or reduce the compensation of a trustee if he's breached his fiduciary duties. Also under the estates code, if an executor fails to take care of or manage estate property prudently, or if he's removed the court can deny his compensation. As I said, damages aren't required, but these remedies all must be specifically pled in the pleadings. Not every breach will result in a total fee forfeiture by the fiduciary. The court's going to consider various factors, whether the fiduciary acted in good faith, whether the breach was intentional or was it negligent, whether the breach affects the whole trust or just part of the trust, whether the breach created any loss, and if so, whether the trustee made that good, and whether the trustee's services were of value to the entire trust, even despite the breach. Another special fiduciary remedy is profit disgorgement. A fiduciary is prohibited from making any profit from being a trustee. Obviously, this doesn't include his compensation, but otherwise he can't make any sort of profit from his position as trustee. This rule exists to prevent a trustee from letting his personal interests conflict with the interests of the beneficiaries. The trustee is liable for any profit that he makes, even if there is no breach, and even if there is no damage to the trust. There's just strict liability when it comes to a trustee earning a profit. If the trust instrument attempts to exculpate the trustee, this, in other words, allow the trustee to retain any profit he earns, by statute, this provision is unenforceable. A very important remedy, of course, with fiduciaries is removal. If a trustee has materially violated or attempted to violate the terms of the trust and it causes a material financial loss to the trust, then under the trust code he can be removed. He can be removed if he becomes incapacitated or insolvent, if he fails to make a required accounting, or if the court finds other good cause for removal. Similarly, under the estates code, an executor can be removed if he fails to file an inventory, if he has misapplied or embezzled or is about to, if he fails to file a required accounting, if he fails to comply with the notice provision, whatever that new section is, where they have to notify beneficiaries after the will's been probated, and if he engages in gross misconduct or gross mismanagement or becomes incapacitated. Accountings can be a remedy. They aren't always a remedy. Any beneficiary is entitled to an accounting, but often when the trustee is not being forthcoming with information, the remedy, at least the initial remedy, may be to demand an accounting. Under the estates code, an accounting can be demanded, as I mentioned earlier, not until 15 months has passed. Under the trust code, a beneficiary can demand an accounting from a trustee at any time, but not more than one time a year. And also under the estates code, a principal can demand an accounting of his agent under a power of attorney, and if the principal is deceased, the principal's personal representative can demand the accounting. Now, sometimes that creates a problem when, as is often the case, the agent under the power of attorney is the same as the executor of the principal's estate, and that executor is not likely to demand an accounting from himself. The statute seems to have a little bit of a glitch there, and I know that our illustrious reputable board will take care of that. That would allow, if the representative and the executor won't demand an accounting from himself, that it would allow the beneficiaries to demand the accounting on behalf of the estate. Okay, another remedy is receivership. This is specifically allowed under the trust code. Professor Beyer mentioned a case today in his case update that that indicates that appointing receiver is it's an extraordinary remedy, and that the courts just don't automatically appoint receivers. but a court may appoint a receiver to take possession of trust property and administer the trust to remedy a past or possible breach of trust. A receivership is not a lawsuit in and of itself. It's ancillary to another cause of action, such as a breach of fiduciary duty lawsuit. Where I find a receivership can be extremely helpful is where you have a fiduciary and you want to have him removed, but there is ongoing dissipation of estate or trust funds. A removal action is not an expedited proceeding. It's a lawsuit. It takes time. The defendant is entitled to all the due process that any defendant is entitled to. So a receivership may be a way that if you have sufficient proof of dissipation and that the estate or the trust will be damaged during the interim proceeding, then the court may be willing to appoint a receiver to take over the trust during that removal proceeding. Receivership statutes are governed under the Civil Practice and Remedies Code, and you will have to show that there is a danger of loss, removal, or material injury to the property. Injunctive relief also is available in the same way as a receiver. It may be, again, a way to get some expedited relief where you just need to stop the trustee from doing certain actions or to force the trustee to take certain actions. Another sort of overlooked remedy, I think, is the appointment of an auditor under the Civil Procedure Rules 172. This is a fairly odd-worded provision. It says that when an investigation of accounts or examination of vouchers appears necessary for the purpose of justice between the parties, the court shall appoint an auditor to state the accounts and make a report. One place this may come in handy is if the trustee is not providing an accounting or not providing an accurate accounting. You may be able to get a court to appoint an auditor to do that for you. A very important remedy to all of us is the remedy of attorney's fees. It's also important to fiduciaries. Anytime there's litigation against a trustee, that trustee or executor wants to use estate or trust assets to defend himself and always claims the absolute right to do so. Well, that's not necessarily true. A court may award attorney's fees as is just and equitable under the trust code in trust proceedings. A beneficiary who compels a trustee to account may recover fees. And although it's not in the statute, a trustee who is removed for cause is highly unlikely to recover his fees from the trust. It's very unlikely a court would find that to be equitable and just. And you may be able to get a court to enjoin a trustee from using trust or estate funds during the lawsuit to pay his fees if the circumstances are sufficiently egregious. Attorney's fees under the probate code or the estates code allow representatives to get their fees from the estate. There is a provision under the estates code that allows an independent executor who defends a removal action in good faith to get his fees paid out of the estate. A party seeking removal of an executor may be able to recover fees out of the estate. But again, in my experience and my view of the case law, in the treatises, a fiduciary whose misconduct has caused the lawsuit is not going to be allowed to recover his fees out of the estate. Exemplary damages are recoverable for breach of fiduciary duty claims. They're covered by Chapter 41 of the Texas Civil Practice and Remedies Code. You first have to be able to recover some actual damages. It requires that the jury be unanimous, and it requires clear and convincing evidence of fraud, malice, or gross negligence. The courts are going to consider various factors in determining whether exemplary damages are appropriate, and I'm not really going to spend time on that. Something I think that is very important in connection with exemplary damages in breach of fiduciary duty cases is that they may qualify for an exception to the cap on exemplary damages. Currently, the statute provides that exemplary damages are limited to the greater of either 2 times economic damages plus non-economic damages, and that can't exceed $750, or $200. So you can either get no more than $750 if you can get up to that amount, or $200, whichever is greater. However, that cap does not apply to conduct constituting misapplication of fiduciary property as defined under the Texas Penal Code, Section 3245. Misappropriation of fiduciary property is defined as a person who intentionally, knowingly, or recklessly applies property he holds as a fiduciary. And a fiduciary includes a trustee, a guardian, an administrator, an executor, a conservator, a receiver, an agent, and just about any fiduciary that you can name. You need to plead this and prove it. Sometimes just pleading for this has a real strong impact on the fiduciary who didn't realize that there is potential criminal liability for breaches of fiduciary duty. Okay, let's go on to the cases that I wanted to talk about. The first case, and there's 2 cases, neither of them are Texas cases, but I just think that they are good cases to illustrate some of these concepts. This case is an Illinois case. Now, in this case, Tom and Bill were brothers, and they co-owned and operated an automobile dealership. They had a corporation, and each was a 50% shareholder. And then the land and the building used for the automobile dealership was owned outside of the corporation. They each owned 50% of the land and building. Tom died. Tom's will named his wife Helen as the beneficiary of his estate, but it also named Bill as the executor. It says trustee, but I'm an executor. And Bill also is the president of the automobile dealership corporation. There was a corporate stock redemption agreement that required the corporation to purchase the deceased shareholder's stock at fair market value at date of death. And the fair market value was to be determined by a CPA selected by the corporation and by the shareholder together, the shareholder's executor together. Of course, in this situation, Bill was in both of those positions. Bill selected, as the president and as executor, he selected his cousin Gordon as the CPA. And apparently Gordon and Bill didn't care much for Helen. Gordon determined the fair market value of the stock at around $600,000, and he also determined the real estate value at around $600,000. But this was taking months, and there was I believe it was a 6 or 9 month deadline that this had to occur. And during that period, Helen's attorneys were asking for information, were contacting Bill's attorneys, and they weren't getting any response at all. So finally, Bill gives Helen's attorneys the appraisals 1 week before the scheduled closings on these sales. Well, Helen wasn't happy with the appraisals. She filed suit to get a temporary injunction, but the court denied that, and Bill refused to postpone the closing and went forward with it. The facts also say that a few months later, Bill obtained a second appraisal of the real estate, which reflected a much higher value. And then he really got greedy and had Gordon prepare a revised appraisal of the stock at half the price they had originally appraised it. Of course, Helen sued, and it took a long time, but finally, after 4 years, the jury found that Bill had breached his duty of disclosure to Helen, He breached his duty of loyalty to Helen by acting in his own personal interests as opposed to Helen's interests. He'd engaged in self-dealing by being on both the buyer and the seller, and that his actions constituted bad faith. Causation here was pretty easy to establish because Bill's failure to disclose the appraisals and failure to obtain proper appraisals and failure to give Helen any meaningful opportunity to evaluate the appraisals all resulted in the sale of the property at less than fair market value, which clearly injured Helen. So what were the remedies that the court crafted? Well, first, the court voided the sales. The court appointed an independent appraiser and ordered new appraisals of the stock and the land and awarded damages to Helen. And the damages were calculated as follows. The new fair market value of the stock was found to be $1,154,100, less the $628 that Bill had paid, so Bill owed an additional $525,000 for the stock. The real estate was valued at $1,300,000 versus $600,000, so Bill owed another almost $747,000. In addition, since the court voided the sales, Tom's estate had been the owner of 50% of the stock for the 4 years and an owner of the land and building for the 4 years. So his estate was owed lost rents for 4 years of $547,000 and also lost profits from the corporation of $222,000. And it seemed to me Bill really shot himself in the foot there, because if he'd sold the property back when he was supposed to, even at the higher value, he wouldn't have had to pay these amounts. In addition, Bill was removed as an executor. He had to forfeit all his executor's fees. He had to repay all the legal fees that he had paid out of the estate. And he was hit with punitive damages, including the payment of all of Helen's legal fees and the costs of administering the estate that resulted from Bill's bad faith actions. So this illustrates how the court can kind of craft the remedies to put the beneficiary back into the position that she would have been in had the breach not occurred, and how you're not limited to just one remedy, only one, you can't get a duplication, but that multiple remedies are available. 3 minutes. Okay. Well, I will just tell you quickly on this last hypothetical. Mom died, and this is very common. Mom died in 1999. Her estate passed through an inter vivos trust, divided into 4 shares for her 4 children. Pam, one of her children, Pam, Jeff, Lisa, and Ken. Pam's share went outright. The other 3 went in trust. Ken was disabled and had a special needs trust. Pam was the executor and the trustee of all the trusts. Mom's assets were about $2 million and a house of $420,000. Just an aside that I probably won't get time to talk about, but there was one stock constituted about 34% of the holdings, which Pam ended up selling to pay estate tax at a substantial loss. It had dropped about 40% in value. The thing that happened here is Pam just completely disregarded her duties. Didn't indicate whether she just had bad advice or what the problem was, but she went for 4 or 5 years without responding to any of the beneficiaries' requests for information, requests for distribution, and this was one of those, bad facts case where one of the brothers was being deployed to Saudi Arabia and was in desperate need of some child support assistance. The other one, Ken, the disabled, he had 3 or 4 lawyers who sent letter after letter with all kinds of problems that he had. He lost his apartment. He went off the wagon. He got depressed. Just problem after problem, and she just made no response. A fiduciary just can't do that. Eventually, they filed suit. Pam resigned after being required to provide an accounting. which showed, of course, she distributed her share to herself and paid herself fees, but had distributed very little else. And she was found to have breached every duty, possible. Although the court did find that she didn't act with malice, and that would have been required for punitive damages. But the damages, she had to pay damages, of course, giving each child their full share of the estate. Her fees were disgorged, and her fees, she had to pay her fees personally, but she didn't have to pay her brother's fees. So I think, this, I'll just say briefly that this is a common situation that I see, where 4 children and the parents want to choose one child to be the trustee or the executor. Many times, I know this never happens to your clients because they're all wonderful families and get along and everything works out perfectly, but this often creates a really bad situation. And to me, even though it involves additional expense and maybe additional time and burden, that either, if you're going to appoint one, appoint all. If you're going to appoint a child, appoint them all, or appoint a corporate trustee or independent trustee. And for my last 30 seconds, I just want to thank Professor Beyer and his wife for their wonderful hospitality, and really to give a special thanks to all of the members and the students and members of the journal who have gone out of their way. I have never been made to feel so special and so appreciated at any seminar, and I know you spend a ton of time, and it really shows, and we just really, really thank you all for that. Thanks for your time.
All right, thank you, Ms. Burdette. It is now time for our final break of the day. Before we break, I have 2 quick announcements. Paid registration for today's CLE and Expo includes a free 1-year subscription to our journal. Additionally, if you were a speaker today, you also get a free 1-year subscription to our journal. That being said, we actually have hard copies of our most recent publication, which is Volume 6, Book 1, at the EPJ booth over in the forum. So stop by, tell them your name, they will cross you off the list and hand you a journal. If you do not qualify for a free subscription, but you are interested in purchasing our annual subscription, please come find me and I can give you more details. And then finally, if you have not entered the drawing for the gift basket for Centennial Bank, please do so, because they will be announcing the winner at the end of the next 2 presentations. All right, please be back. The next presentation will begin at 3:25, so if you guys will be seated before then, that will be great.